Amended House Bill 663, Representative Beaky, Huffman, and others, to amend section of the revised code to provide confidentiality and license protection for persons and entities involved in executing a sentence of capital punishment by lethal injection to void against public policy any agreement that prevents the supplying of any drug or drugs to be used in executing a sentence of capital punishment by lethal injection, to amend version of section 149.43 of the revised code that is scheduled to take effect on March 20th, 2015, to continue the provision of this act on and after that date.
Question is, shall the bill pass? The chair recognizes Senator Eklund.
Thank you very much, Mr. President, members. I rise to urge support for substitute House Bill 663. Currently here in the state of Ohio, in section 2949.22 of the revised code, we provide for the administration of a death sentence by lethal injection. Nothing in this bill that's before us today adds to, subtracts from, alters that reality. This is not a bill to tamper with or, in any respect, that fundamental aspect of the administration of justice here in the state of Ohio. What the bill does do is it addresses some very serious concerns that have arisen with respect to the ability to execute that law in a manner consistent with Ohio law and as public officials of the state of Ohio are sworn on their oath to do. What has happened is that some of the drugs that could be used for purposes of administering the death sentence have become difficult to obtain here in the state of Ohio. And frankly, some of the drugs that are difficult to obtain are, we are told, some of the most appropriate, effective means by which to administer the death penalty in a painless, most humane manner possible. This has happened for a couple of reasons. Number one, the suppliers of drugs have come to place into their distribution agreements provisions that say these drugs may not be resold for purposes of performing a death sentence, an execution. And the distributors of these drugs, therefore, are bound contractually not to deliver them into the hands of the authorities who are in a position to use them to this end. The other thing that's happened is compounding pharmacies who are in a position to compound the substances that can be used to administer the death sentence in a humane and painless fashion have become the subject, and I mean not to argue for or against or speak with any disapprobation to this, except to say it is a fact that they have become subjected to not just criticism, but downright attack and boycotts and picketing at their homes, and they and their families have become subjected to the kinds of things that none of us would want to be subjected to or would want our families to be subjected to, whether we agree with them or we don't. And consequently, many of these pharmacies find themselves unwilling to subject them and their families, and their businesses, quite honestly, to that sort of public disapprobation and excoriation. And so the drugs become more difficult to obtain. This bill proposes a number of means by which to eliminate those obstacles and allow those who bear this very, very, very heavy responsibility to perform their duties the ability to administer the law in the fashion that they are sworn to do. The bill came to us with a number of provisions. Number one, it would make the identification of individuals who participate in the administration of the death sentence outside the scope of the public records law. In other words, not disclosable under the public records law. It would extend the same confidentiality to companies or individuals who provide the drugs or the instruments through which the death penalty is performed. Under the bill, for individuals, that is to say, for example, employees of the Department of Rehabilitation and Correction who actually perform this most grave act, would be given this protection of their identity without having to ask for it. For non-individuals, presumably those who are more in a position of providing the materials and the wherewithal with which to perform the act, those folks would have to apply for this level of confidentiality. And if it were granted to them by the Director of Rehabilitation and Correction, they would maintain that confidentiality for a period of 20 years. After 20 years, their identity would be able to be revealed. Now, the bill as it came to us also contained a provision that would have voided as against public policy any contract, agreement, understanding, etc., that had anything in it that prevented the distribution or the sale of these materials to the state of Ohio for purposes of performing this act of state. We took a number of amendments to the bill in committee, and I would like to review them with you just briefly, if I may. First, we took a number of amendments that adopted and codified in Ohio law recommendations that had been made by the Supreme Court of Ohio's task force on the death penalty. We took an amendment that provided for appointed counsel in capital cases, defense counsel this is, to receive fees for their services in an amount to be set by the Supreme Court. We took an amendment that says that in these capital cases, when there is a claim afterwards of ineffective assistance of counsel, that is, the lawyer gets sued by the defendant for malpractice, that the attorney-client privilege no longer applies in those contexts, and the plaintiff may use his communications with counsel to prove his case, and the lawyer may use her communications with the defendant in order to defend herself, a fairness amendment. We took an amendment which provides that in capital cases, that the instructions that are given to the jury, usually orally by the judge, and I don't know if you've ever been on jury duty, but basically what happens is the judge stands up there and reads the instructions of the law to the jury, which in most cases the jurors are expected to sit back, absorb that, remember it, understand it, then retire to the jury room and deliberate on those instructions of law along with the facts. The amendment we took today requires that those instructions be in writing, that they be provided to the jury in writing, and that they be allowed to take them into the deliberation room so that they can read them, think about them, argue and discuss them, and maybe, can you imagine, understand them. A very, very positive use of that practice. We took an amendment that established a legislative study committee made up of members of the legislature appointed by the Speaker of the House, the President of the Senate, and thanks to the good work of Senator Skindell, now includes an appointment by the minority leader in both the House and the Senate to consider a couple of things. Number one is to consider ways in which the state of Ohio can better assist the families of victims of murders to overcome and deal with their circumstances. There's sometimes, oftentimes, maybe, sort of the forgotten victims in these homicides that people have to live with a lot of stuff when a loved one has been killed. And this study committee will review ways in which the state of Ohio can do a better job of lending support to those sometimes forgotten victims. As further amended, the committee has another function, and that is to study the means and the manner by which executions are performed here in the state of Ohio, all within the bounds of existing constitutional and judicial precedent as to what is and what is not allowed, and both with long-term and short-term consequences taken into account, and to make recommendations with regard to those issues. We took an amendment that would require any supplier of drugs to the state of Ohio for this purpose, the identity of those people to be disclosed to the Ohio Ethics Commission. Why? Because we want to make sure that whatever the relationship is between these providers of these drugs and the state of Ohio does not violate the ethics laws of the state of Ohio. And the Ethics Commission is charged with the responsibility of assuring that there's no monkey business going on in that relationship in the case of a capital case. The Ethics Commission also will determine, in that context, and whether or not those who are providing the drugs to the state of Ohio have or do not have all of the licensure that they are obliged by Ohio law to have. In other words, the opportunity for the state of Ohio to go out and contract with John Eklund to cook something up in his garage to perform an execution is thereby foreclosed. These are very important protections, and they're very important internal watchdog provisions that we have added through the committee process. We took a couple of amendments further defining the kind of information that was subject to this confidentiality. The bill that came over to us said any information that identifies anybody who participates in this process. We regarded that as mildly too broad. So we narrowed it. We narrowed it to only information that identifies the participants in the process, and only insofar as that information connects them to the process of administering the death sentence. If we didn't do these amendments, the name of every drugstore who ever provided, or every compounding pharmacy that ever provided a drug to the state of Ohio would be forever secret in whatever context, in any context, and it was a little bit too broad, so we narrowed that down. The bill also provides for mechanisms through which the courts will deal with this type of information in the event that the information comes to the court's attention. It will require the court to seal the information under procedural protections that are in place, and we had to make sure that what the courts are required to seal is consistent with the amended description of what it is that we're trying to protect as confidential. Then finally, we took an amendment that, not finally, but we did take an amendment that eliminated from the bill those provisions that would void contracts. And we did that for a couple of reasons. One reason was because it carries, in the opinion of many who were involved in this process, some serious constitutional implications. Contracts, as the lawyers in the audience will know, do rise to the level of constitutional protection, and their sanctity is to be protected. And this bill went contrary in some respects to that principle. But more importantly, what we learned through the committee process is that the reason why many of the drug suppliers put those clauses in their contracts that I talked about earlier that says thou may not sell them for purposes of an execution goes to the fact that many of these drugs are manufactured in Europe. Well, in Europe, they have a regulation, the EU has a regulation that says any drug that could be used in an execution will be embargoed. That is to say, the European Union can prevent its export to other countries. Well, the problem is many of these drugs have very, very beneficial and useful purposes in the ordinary day-to-day administration of medicine and medical care in the United States and throughout the world. One of them we heard about was propofol, which is one of the most widely used anesthetics in surgeries in the world. And I can't remember the number, whether it was 85% of the surgeries in the United States are performed through the administration, with the administration of this propofol. And the manufacturers of the drug have been able to convince the EU that if they put into their distribution agreements this language that says you may not use this drug for executions, the EU takes the position, fine, that means it's not one of those that could be used in an execution. If we voided those contracts here in Ohio, then the EU almost certainly would embargo those drugs. They would no longer be available for their very many beneficial and necessary uses in the medical practice. And we heard great testimony from people in the anesthesia world who said that that would be devastating to the practice of medicine and the appropriate, purposeful administration of medical care here in the United States. So we removed that as well. Finally, there were some provisions in the bill that came over to us from the House which sought to have us declare certain things, and that we had found certain things about the state of affairs in this area here in the state of Ohio. Well, we removed some of that and substituted it with a statement of purpose of the bill. And the statement of purpose of the bill is really pretty straightforward. And it is essentially to protect the confidentiality of and the identities of these individuals who, many of whom are employed by the state of Ohio, doing a job, a very difficult job, to feed their families, and the idea is to protect their identity, and that's what we're trying to do. Mr. President, members, this is about the administration of the laws of the state of Ohio by good, decent people who pass no judgment necessarily on issues related to the death penalty, except that they have a job to do and they need to do it. And we as a society have a responsibility to see that the laws of the state of Ohio are administered in a fair, even-handed way. This will allow that process to go forward. I urge your support for the bill. I want to thank, and Mr. President, I want to apologize for any extent to which the committee's failure to complete the work on this bill before this morning disrupted the orderly process of session here today. It was by no means the fault of any of the members of the committee who worked diligently and consistently and persistently to get this done. So insofar as there is any fault in this, I accept full responsibility for it. But I thank all the members of the committee for their hard work. I thank the members, the minority members, for their insightful and thoughtful questions and their suggestions with regard to the process. And I urge you all to vote in support of the bill. Thank you.
Question is, shall the bill pass? The chair recognizes Senator Lehner.
Thank you, Mr. President. I rise this afternoon to explain why I will be voting no on this legislation. The decision to evoke the death penalty in a particular case resides with the court, but the court's authority to do so, as well as the corrections system's legally required obligation to carry out that execution, comes directly from this legislative body. Therefore, each and every one of us, by our actions, has a hand in authorizing the death penalty here in Ohio. That is a responsibility unlike any other we bear, and one that we can never take lightly. It requires our most thoughtful deliberations. It is also a role that sometimes put our personal beliefs to a deep test. That is certainly true of the legislation before us today. I personally cannot take refuge in the notion that our actions only assure that Ohio's laws are safely and humanely carried out, for we are the ones who make those laws. As I have listened to this debate over the last several weeks, there have been some recurring themes that just bother me, and I'd like to share them with you because I find it hard to believe they don't bother all of us. Shouldn't it cause us great discomfort to know that we find ourselves trying to figure out how to assure confidentiality to drug companies, not just small compounders, but large international drug companies? Because no business wants to publicly admit that they are playing a role in Ohio's executions. Does it bother us at all that no other country that we normally regard as our ethical allies are willing to allow these drugs to be sold on the open market because these countries consider capital punishment to be an antiquated, barbaric practice? Does it bother us that we have great difficulty finding physicians to oversee lethal injections because it violates the most basic ethical codes of their profession? Is there any irony in our willingness to take the life of a convicted killer but worry endlessly that we don't cause them any suffering? It seems to me that each of these questions should at least give us some pause. Certainly compel us to pause long enough to not rush this legislation through a lame duck session. I hope that at some point we will openly debate the question of whether or not Ohio should join 17 other states and most of the developed world and discontinue the use of the death penalty. In the meantime, I will have to vote no on this legislation. I cannot separate our vote today from the end result, which will be the actual execution of a very real person. I have no sympathy for those who commit violent crimes, especially when those crimes involve the taking of a life. However, my personal belief is that the taking of life must be reserved for only those times when we have no other available means to protect society from a grave threat. Because other ways of punishing convicted criminals are available to us, I cannot and will not participate in carrying out Ohio's death penalty. I urge a no vote on this legislation. Thank you.
The question is, shall the bill pass? The chair recognizes Senator Jones.
Thank you, Mr. President, and thank you, members, for the opportunity to speak to you today on this bill. I, too, rise in opposition of the bill, but before I speak to the heart of the matter, I want to be very, very clear that I do not question at all the professionalism and the commitment of Chairman Eklund and the entire committee and everyone who worked on this piece of legislation. This is a difficult issue for all of us, and I respect them and their work. I don't doubt their intentions either, which is to try to fix a problem that has arisen as a result of the law that we have. And indeed, I believe my colleague and friend from the 18th District has made a very good case as to why this bill has been made substantially better than it was when it came to us from the House. But I, too, find it very, very difficult to separate this bill from the idea of the lethal injection, albeit in flux right now, and the death penalty in general, not because I'm against the death penalty, because my record has been one of support of the death penalty in the past, but because I'm conflicted about that viewpoint. And so I rise today to explain to my constituents, those I serve, my no vote, and also because I feel I have a duty to do that when the issue rises to such magnitude. The state's taking of a human life is probably the most significant thing that we can do. And talking about this issue without respect to the ethics, without respect to the significant issues surrounding the fulfillment of this law is one that's really difficult for me to reconcile. So on one hand, as someone who's deeply pro-life, who's always made a distinction between the taking of innocent life and those who've been found guilty of the most heinous crimes in the best courts of law in the world, can't help but be haunted by things like new evidence, DNA evidence, that has indeed exonerated people of heinous crimes. I can't, on one hand, advocate for legislation that protects the DNA evidence, that advances DNA evidence as a way to continue to both find perpetrators of heinous crimes guilty, but also exonerate those who are falsely accused and imprisoned, and not consider that in this debate. But on the other hand, when I read those stories of some of the most heinous crimes that I can't even imagine against children and the elderly and the vulnerable, I too become a supporter of this law that I'm sworn to uphold. And so I'm simply here to say to my constituents, I don't think I'm any different than most of them if we're forced to think about this. And indeed, it would be much easier if we didn't have to think about these issues, if we could think about it simply as contracts and obligations in order to fulfill an existing law. But I'm conflicted. And since I can't reconcile or separate that conflict that I have, I simply can't vote for this bill outside of the larger debate of what exactly it is we're doing in this state. So again, Mr. President, I respect this chamber and the people who serve in it. And I respect the varying opinions, not only on this piece of legislation, but all the tough issues. But this rises to a much greater one that I think is worthy of more consideration and more debate and a broader perspective. And for that reason, I will be voting no. Thank you, Mr. President.
Thank you, Senator Jones. The question is, shall the bill pass? The chair recognizes Senator Brown.
Thank you, Mr. President. Mr. President, permission to speak to the bill. I rise, Mr. President, to
explain why I will be voting against this bill. Originally, I had intended to introduce a 184-page amendment, which would explain my strong opposition to the death penalty. I would have spoken much longer. However, for the sake of everyone's time, and especially for our hard-working friends at LSC, I decided to give just a few brief remarks. While the primary premise of HB 663 is to grant confidentiality and immunity for manufacturers of lethal injection drugs and persons carrying out the procedure, at the end of the day, we are still promoting capital punishment. Personally, I think everyone knows I am very much opposed to capital punishment. And research and experience has told us that capital punishment fails in almost every regard as public policy. And in my opinion, there's always the possibility of executing an innocent person. 10 men in Ohio have been exonerated of crimes they were sentenced to death for, 3 of them within the past year. Clearly, mistakes have been made and they will continue to be made. The death penalty task force commissioned by the Ohio Supreme Court made recommendations to improve the flawed capital punishment system in our state. Amendments were added to this bill, which incorporate some of those recommendations, but not nearly enough. Franklin County Prosecutor Ron O'Brien stated, "The implementation of all of the task force recommendations would effectively eliminate the use of capital punishment in Ohio." I think this is a fantastic summarization of the problem. Reforms to make capital punishment fairer, more equitable, and reduce the possibility of executing an innocent person would eliminate a prosecutor's ability to pursue those cases. If that isn't an argument to discontinue the practice altogether, I don't know what is. Another argument to discontinue executions permanently is the need to bend over backwards with measures like HB 663, granting confidentiality and immunity. The fact that we're attempting to do that in this bill further convolutes this already broken system. I ask, why is this necessary? When we could save Ohio taxpayers millions of dollars by simply abolishing capital punishment altogether and eliminating the possibility of executing an innocent person, I do not support this bill, and I hope others will not also. Thank you, Mr. President.
Thank you, Senator Brown. The question is, shall the bill pass? The chair recognizes Senator Kearney.
Thank you, Mr. President. I rise not so much to deconstruct the bill, but to just raise some issues that I would like for my colleagues to consider. I thank the senators from the 6th, 7th, and 11th districts for their thoughtful and wise comments. I'm concerned about two points. One is the number of hearings that we had on this particular issue. There were 3 hearings. This is a very complex issue. I think that we should have had a little bit more time to deliberate about it. That is not to say that the senator from the 18th district doesn't run a very good committee. I'm not arguing that. He's a very fair committee chairman. He allows for open discussion. But I just think we could have had more discussion. Second point, I think that there is a confidentiality creep that is going on, a transparency concern that is going through a number of different bills. And this is one example of it. We're allowing government to hoard information. We're decreasing the amount of disclosure and transparency. And so I would just like for people to consider that. Is that what we want to do? Do we want to have our government hold all this information? Is the definition of what a public record is the way we would really want it, or should we consider a more open definition? So, colleagues, for those 2 reasons, I'd like for you to consider those as you make your vote.
Thank you, Senator. The question is, shall the bill pass? The chair recognizes Senator Skindell for an amendment.
Thank you, Mr. Chair. Move to amend with Amendment 4691.
The amendment is in order. Senator, please describe your amendment.
Thank you. This will just take a moment. I first want to commend the chair of the committee and who is also the manager of this bill on this floor. Sir, you in committee, under the circumstances we were dealt with lame duck, was thoughtful, was fair, was deliberate with respect to your handling of this bill, and I greatly appreciate that. And all of our members here on this side also greatly appreciate that. What this amendment does, it shortens the time period from 20 years to 10 years in which a person entitled to the rights of confidentiality can have those rights. During the committee, as partially described already by the manager of the bill, they've tried to deal with this a little bit, and the effective confidentiality time period was shortened under some amendments of the bill. However, we believe that it should be shortened even further, and I would recommend passage to ensure that we maintain integrity in the system. Thank you.
The question is, shall the amendment be agreed to? Chair recognizes Senator Eklund.
Thank you, Mr. President, and thank you to the senator from the 24th District for his amendment. We considered this in the committee and did not act upon it. Based upon the information that's been available to me and to some other members on the committee, we understand that the original permutation of the bill called for something on the order of 50 years of confidentiality. In fact, it may have started out over in the House with perpetual confidentiality for all corporations, non-individuals. But it was negotiated down to 50 and then ultimately to 20, and I am given to believe that it landed at about the right place in order to provide the level of comfort to those who enjoy those 20 years of protection, that they can go forward and deal with the state of Ohio without suffering the inappropriate public excoriation, as I've said, that they sometimes face. So I would urge a no vote on the amendment.
The question is, shall the amendment be agreed upon? The chair recognizes Senator Widener.
Thank you, Mr. President. I move to lay the amendment AM 4691 on the table.
The question is, shall the amendment be laid upon the table? Without objection. Clerk will call the roll.
Bacon? Balderson? Beagle? Brown? Burke? Cafaro? Coley? Eklund? Gardner? Gentile? Height? Hughes? Jones? Jordan? Kearney? LaRose? Lehner? Manning? Obhoff? Olslager? Patton? Peterson? Sawyer? Schaefer? Schiavone? Seitz? Skindle? Turner? Eaker? Widener? Faber?
With 22 yeas and 8 nays, the amendment is laid upon the table. The question is, shall the bill pass? Chair recognizes Senator Seitz.
Thank you, Mr. President. It's funny how we sometimes take a bill that deals with A and turn it into a debate about B. And it seems to me that that's what much of the commentary has been about this afternoon. I recognize that there are people who, for very good reasons, are opposed to the death penalty. But that is not what this bill is about. If you would like to bring in legislation to repeal the death penalty, I would invite those members that feel that way to bring that in as the first order of business in January, and we'll have a debate about the death penalty. But if you are concerned, as I am, about how the death penalty is currently administered in Ohio, you should vote for the bill. Because, and I don't mean to toot my own horn here, I had no particular expertise in this area, but I have served for 2 years on the Supreme Court's death penalty task force. And with the departure of our dear friend Senator Smith, who was the other member from the Senate that was on that task force, I'm the last man standing, so to speak. And that task force, which was a broad task force that included defense counsel, professors, judges of every stripe and nature, prosecutors, a handful of legislators, came up with 56 recommendations. Now, not all of them were unanimous. The prosecutors ended up dissenting from about half of them. A more moderate contingent of folks, including me and Judge Wilson and Representative Condit, dissented from only 12. So most of the rest of them had pretty much unanimous support. And this bill, though I did not get to pick and choose which of the 56 recommendations made it into this bill, at least 4 or 5 of them did. So it's a start. It is a start. I admonish everyone in this room not to think it is a finish. Let's not hide behind that fig leaf, because I think in January we better get down to business and introduce several bills that will allow all of these questions to be vetted as fully as they were in the 2 years of service on the death penalty task force. But if you are concerned about wrongful convictions, and I think my record on this subject is as good as anybody is in this chamber, then you should vote yes for this bill, because we are actually acting on these recommendations even before the Supreme Court itself has acted on any of the recommendations, because about 1/3 of the recommendations need to be implemented by court rule and not by legislative action. So we are being very attentive, it seems to me, at least as a starting matter, to that very important task force report, which I hope does not just gather dust on a shelf like so many other task force reports gather. So for those of you that are irretrievably opposed to the death penalty, it seems to me that's another bill. Bring it in and let's have a debate on it. For those of you that are concerned about reducing the incidence of wrongful conviction, you should really think about voting yes on this bill. And if you're concerned about drug makers and confidentiality, frankly, I am too. So that would be the second contribution that I made to this process. And it was Senator Eklund's wonderful work and Senator Hughes and Senator Obhoff. They did 90% of it, but I'm only going to speak about the few things that I had a hand in here. Is that we have charged the committee that this bill creates with looking at the means and manner by which Ohio administers the death penalty consistent with applicable judicial precedent. I believe that's the exact language, my friend from the 18th District, that we put in there at the 11th hour. And I see my good friend and our dear colleague, Senator Cates, in the gallery over there, to whom we should at some point acknowledge a warm Senate welcome. But he will remember, as I believe my colleague from Franklin County will remember, that Senator Grindell is having an I told you so moment. Because when we made the decision some years ago to abolish the use of the electric chair and to put all of our eggs in one lethal injection basket, Grindell voted no. I believe Senator Hughes might have voted no. All right? We made a mistake because we put all of our eggs in one basket that is now being held by European drug manufacturers to whose yoke we are now tethered. And the committee that we are creating in this bill will look at alternative means, which, if consistent with applicable judicial precedent, could be employed to administer the death penalty without any need for any confidentiality, without any need for any of this stuff. But until we get that all vetted and sorted out, we've got to do something in the interim, and that's what this bill does. It is not just so simple as postponing an execution scheduled to take place in February. It's not that easy, and hopefully some of the other senators that worked on this bill can explain that later. But we are making progress in this bill towards untethering ourselves from this European drug cartel, all right? And to me, that's a good thing, because there are plenty of alternate means that have been approved by the United States Supreme Court as being not cruel and inhuman punishment within the meaning of the applicable Eighth Amendment provision of the United States Constitution. And it seems to me we might want to deliberate over having other tools in the toolbox, so to say. The third thing that I had a hand in that I think is very important gets to the reasons why people are concerned about confidentiality for the compounding pharmacies and drug companies. My concern about that was, how is anybody going to vet or know whether the people that are involved in the process are really licensed to do the job that we've contracted with them to do, or are we instead using Mr. Gower, if anybody remembers It's a Wonderful Life, who in a drunken stupor was just about to mix up the wrong drug and kill somebody before little Jimmy Stewart told him not to, and saved the whole situation. You remember that. We need confidence that we're not going to be contracting with some unqualified, disbarred, unlicensed individual. And at the same time, we need confidence that the person with whom we are contracting is not the brother or business partner or other relation of somebody in state government, or is paying somebody a bribe to get the contract. In other words, we need to enforce the ethics laws of the state of Ohio. So the amendment we took this morning, I think it was this morning, says that the Director of Rehabilitation will submit the whole kit and caboodle to the Ethics Commission of the state of Ohio, which will undertake a review to determine that the proposed transaction complies with the Ohio ethics laws and that the people who are involved in the process are licensed to do what they purport to do. So the public, though it will not know the identities of these individuals, the public will have the confidence that the Ethics Commission of the state of Ohio, which has been certainly no stranger to enforcement of such things, will have signed off that everything is on the up and up from an ethical point of view. I think these are material improvements to the bill as it came over from the House. This was never a secret execution bill, by the way. The execution process will remain as fully open once we pass this bill as it was prior to the time we passed this bill. No one is taking somebody into a room and the usual routine of witnesses is completely unaffected by this bill. So I think this is a pretty solid bill. I look forward to having either a debate on the death penalty itself or a debate on the remaining recommendations of the task force. That is two important debates we can and should have. But, for example, some people point out to DNA. Well, I know quite a bit about that, too. The trouble is there's not always DNA evidence, as my prosecutor friends pointed out. In the Oklahoma City bombing case involving Timothy McVeigh and some sidekick of his, whose name I forget at this late hour, there was no DNA evidence linking those people to that heinous crime. In 9/11, though all the terrorists died in the resulting aircraft crashes, there wasn't any DNA evidence that was going to link them either. So sometimes you need to have the death penalty. If you think that the Oklahoma City bombing or 9/11 qualify as heinous crimes, I would certainly hope we all agree on that. It may not always be possible to have DNA evidence to prove that Timothy McVeigh did it. These are all difficult questions. They were pondered at excruciating length in those committee meetings, which went on for most of the time, 3/4 of the day we gave up sitting there. So it's a good debate to have, but for now, we've taken good steps forward, good faith steps forward to get something done. And until we've had that debate that we need to have, this is what we need to do today.
Thank you, Senator. The question is, shall the bill pass? The chair recognizes Senator LaRose.
Thank you, Mr. President. I wanted to rise briefly on this one. I think that we've gone over this a couple times now, but I just wanted to state my opinion that very clearly, in my mind anyway, a vote in favor of 663 is not a vote in favor of the death penalty, nor is a vote against 663 a vote against the death penalty. It's not quite that simple. Most of the work we do here is not quite that simple or black and white, cut and dried. And our colleagues did good work on this. They've worked hard and they've worked diligently, and I think that they've produced a product that's better than the one that came over, and I think that our colleagues in the House did the best work that they could do as well. Nor am I saying anything about the work that the men and women at DRC do. We ask them to do a very difficult job when they carry out the state law as it relates to this penalty. Thankfully, we have individuals who are willing to do that job and do so in a professional manner. But I do believe that we have to talk about this change to the law in the context. What we're talking about here is the most serious thing that government can do. Government can take your money, they can take your freedom and put you in jail, they can take your parental rights away. There's a lot of things that government can take from you. None of them are more serious than this very final thing that government can take from you, and that is to take your very life. Most things we do can be undone. This one cannot. I think that to the extent that this most serious act that government can do needs to be conducted with any secrecy, then we probably ought to wait until we find a better way to do it. I think that making secret how we receive the drugs necessary to carry out this penalty is a mistake. I think that we've talked about that there are opportunities to study this and find new ways, opportunities to refine the way that we carry out this penalty, or to have the debate about whether we should have this penalty anymore at all. But I don't think that there's an urgency to get this done tonight. And the vast majority of us will be back here next year when we can have this conversation and talk about better ways to get this done. In the meantime, these individuals who are convicted of these heinous crimes will be safely tucked away in a state facility where they can do no one harm. And we will have the opportunity to consider their ultimate fate at another juncture. This one has caused me some great contemplation. And I know that for many of us it has. And so I don't think that anybody's vote on this is something that anyone should read more into than a simple debate over whether this procedure should be done with any degree of secrecy. I, however, believe that we can wait until a later date to figure out a way that we can carry out executions without protecting the identity of those that provide the drugs. With that, I urge a no vote, as I'm going to be casting a no vote on substitute House Bill 663. Thank you, Mr. President.
Question is, shall the bill pass? The chair recognizes Senator Eklund.
Thank you, Mr. President, and I'm so very grateful for the very heartfelt and thoughtful comments surrounding this bill, and I take to heart the comments of the senator from the 11th District and the 8th District and the 7th District, all very, very heartfelt, and that counts for something. But I do believe that, you know, if that debate is to be had, it can be had at some other time, and I agree with the senator from the 8th District that this is the right thing to do now. One thing about the bill that I failed to mention in my summary, and I'm very sorry for that, but we did take an amendment which effectively sunsets this law after 2 years. That is in the bill. In other words, for the next 2 years, those who participate in the process of administering the death penalty and those who supply the drugs that are necessary to do that by law will have that level of confidentiality, and it will be either for a long period of time or for 20 years or whatever the law currently provides. But if we do nothing further, then in 2 years this bill goes away, and those who participate in the process or supply the drugs after that will be naked as far as confidentiality is concerned, unless we do something else. What can we do? Well, we could talk about other ways to protect people from public disapprobation, or we could come up with other ways to perform the duty of administering the death penalty. We could do that. But I want you to understand that 2-year sunset provision was very importantly keyed to the committee that I referred to earlier and that Senator Seitz made reference to. That is to say, that committee, we're going to give them a year to get their studying done and their work done. And then the legislature will have a year to deal with those recommendations, if any, and try to address them in a purposeful, thoughtful, grown-up sort of way. And then we'll see what happens and what comes out of that process. But it's really, and we put the 2-year back end on it because, as we all know, sometimes, you know, the work expands to fill the time available to do it. And we don't want that to happen in this case. So I want you all to know that the concept of potentially studying other alternatives and folding them into a broader, deeper analysis on this, on these very, very weighty issues, was something that was all part and parcel and contemplated by the bill as well. And I thank you all again for your very adult discourse, and but I still urge support for the bill, and thank you again.
Question is, shall the bill pass? The chair recognizes Senator Hughes.
Thank you, Mr. President. Members of the Senate, I rise today to speak in favor of this bill. I want to offer a perspective I think is different, while I still respect everybody that spoke before me. But I've had 2 jobs before I came to this august body of the Ohio Legislature, and both of them dealt with the death penalty. When I was in college, I had the opportunity to be hired as a bailiff for Judge Tommy Thompson. Leah Pappas back here was a bailiff on the other side. I was a bailiff for the judge. I did that job for 6 years. During that tenure, there was 13 capital murder cases that were before him in his courtroom. Those cases roughly took around a month to 6 weeks in terms of what occurred from the date of the actual trial starting to the first phase. If it was a second phase, whether it was the sentencing phase, it could add another week to that. As a bailiff, many of you probably aren't aware, but we're in charge of the courtroom. So you had an occasion to get to know the defendants, family, as well as the victim's family. And I guess that's where I'm coming from in terms of why I'm speaking in favor of this. I've also had the unique opportunity to prosecute 3 of these cases. And that gives me a different perspective because even as a bailiff, I got to know the defendant's family as well as the victim's family. As a prosecutor, you get to know because you're with that victim's family so much, and you can know so much about them, you feel almost attached to them. This is a very serious bill. In Ohio, we have the death penalty. I agree with Senator Seitz. If this is something we want to debate, we can debate it later. But the brave men and women of DRC are charged to carry out the law as it's written. And the first thing we need to know and realize is across the nation, we have people who are harassing, threatening, and protesting those companies that produce this, if it's these drugs, these compounds, as well as the chemists. And makes it very difficult for these people to carry out their duties that they're supposed to do. What we're trying to enact here today is no different than what Missouri did, that the U.S. Supreme Court on Wednesday denied certiorari, which means a right to hear the appeal. This bill is modeled after that Missouri case. In addition, the courts have also spoken for the need for the confidentiality and anonymity in carrying out the execution. In Owens v. Hill, 758, 2nd, 794, the court stated, without the confidential offered to execution, participants by the statute, as the record in our case law show, there is a significant risk that the persons, the entities necessary to the execution would become unwilling to participate. What we've done here, and the good Chairman Eklund has been able to do with the committee, with the help of Senator Seitz, Obhoff, and all the members, we've been able to strike a balance where just the confidentiality of the company and the chemist is what we're talking about. And we need to be perfectly clear about this because it's been put out as a misnomer before that. It was stated, we need to remember these cases are reserved for the worst of the worst, the Timothy McVeighs of the world. I also want to talk about something that Prosecutor of Frank County, Ron O'Brien, came in and talked about in committee yesterday. A gentleman named Alvy Campbell. Alvin Campbell was a defendant who was sentenced to life for shooting a trooper and killing him when he was a juvenile. He also had some robbery charges that were pending. He was transported from the institution down to Franklin County, right here a few streets away. He was in a wheelchair. He said he had a back issue. He was not cuffed to the wheelchair. He overpowered a female deputy, took her gun, broke out of the Sally Port, and accosted a 19-year-old man who was coming in to pay a parking ticket on his way to buy a flower or a rose for his mother for Mother's Day. When Campbell was asked about what this was, he took him down to South High, down to Great Southern Shopping Center, which is down a little bit south of 270 for those who don't know it. Took him out in the field, took his clothes, took his car, put the gun to the back of his head, and executed him. When asked about what it felt like or what he did this for, he said it felt like just shooting a bird. This is the type person that we're talking about. He's on death row. He is scheduled to be executed in February of next year. We need to remember the victim's family. That case happened in Ron O'Brien's first term. I was in the office, I was 1998. Think of the family if we do not pass this bill, because that execution will be stayed. Doesn't the victim's family deserve some closure in this? One safeguard, there's many safeguards we put in to make this bill better, but one thing that has not been discussed is something called post-conviction relief that was put in here. We doubled the time. Those are opportunities for a defendant who feels he either had ineffective counsel or wrongfully accused to get new counsel appointed by the appellate court. In this case, the Supreme Court, because it directly goes up there now. But the point of the matter is they review the whole record. We're giving them a year to make sure that somebody is looking at this record to make sure it's correct. In addition, as I mentioned, I was a bailiff. One of the things that I always thought should happen, and I'm glad I was able to put it in this bill, is for the jury. You have to understand, the jury instructions are about the size of about 25 to 30 pages. It's called OJI, as attorneys would know. Think of a lay person sitting here and listening to that for roughly an hour, hour and a half from a judge, he or she reading that to them. In this bill today, those jury instructions will be mandatory to go back with the jury. So when the jury is deliberating, those 12 individuals, and usually 4 alternates, and by the way, they're sequestered, as you may or may not know, will have that back there to look at the evidence as well as reread the law in terms of what's going on. I respect everybody's view in here and what they've said, but I'm voting affirmative for this based upon my experiences, which is with this death penalty is probably more than anybody in this room. I feel it is the right thing we should be doing, and I ask for you to vote yes on this bill. Thank you.
Question is, shall the bill pass? The clerk will call the roll, please.
Bacon, Balderson, Beagle, Brown, Burke, Cafaro, Coley, Eklund, Gardner, Gentile, Height, Hughes, Jones, Jordan, Kearney, LaRose, Lehner, Manning, Obhoff, Holzleger, Patton, Peterson, Sawyer, Schaefer, Schiavone, Seitz, Skindle, Turner, Eaker, Widener, Faber.
Aye. 20 yeas, 10 nays. The bill is passed and entitled.